I'm very happy to welcome you all today. And I would like to begin by asking you to ignore my maxi size on the big screen and to think about our great panel of speakers today. We are very happy today to welcome Ms. Diana Bulancea, who's joining us from the Court of Justice of the European Union online. We're very happy to have two international guests today. Our good friend Değer, who's joining us online as well, and Wojciech, whom we have the pleasure of welcoming here in person. So welcome. As well as our partner, JURIDICE, Daria, thank you for being here. And my colleagues, Ana Maria, Iuliana, and Iulian. And I'm supposed to be the keynote speaker. And as a keynote speaker, I'm supposed to give the key in which these discussions are to be continued today. And it's very hard in these days to find the proper key. Today, at this moment, we're waiting for different keys in Europe, from Kyiv to Jeddah to the Constitutional Court here in Romania. Many different elements shaking and shaping our current state. And in this state, it comes to pass that we discuss what happens with how our union is treating our friends who are not in a bilateral treaty with this union. And it is a question that can be framed today in many ways from a much more principial point of view as to how should this union react to what is happening, to a more legalistic point of view into dealing with how European Union law should be applied in this union. And I don't want to give away anything from the discussions that will follow. The speakers are far more versed in this than I could ever be. But I would like to ask them if they can please maybe touch upon a few of the issues that I have with these two judgments that they mention. And in reading those judgments, the Collin and Qingbao opinion of the AG, you cannot help but find an echo of how another country is dealing with partners today. That is, we treat them as they treat us, and we apply our laws as strictly as we can, demanding reciprocity at all costs. And that does say something about both our understanding of what our union stands for and of the state of the world and other companies who participate in our public procurement. And it is in this context that maybe we should think about whether what I feel is a formalistic approach by both the AGs in both cases and the court is consonant with the expectations of the founders of the European Union, who focused on healthy competition, solidarity, and a union of minds. And I have recently been going through some of the very interesting talks that Jacques Delors, who passed a few years ago, gave in the European Parliament, in the European Commission, even in 1995, I think. And I find that the question principally should be whether in this international context where the world grows meaner, the European Union should grow meaner as well in response, or whether it should try to find the ways to keep its friends and partners closer. And therefore, I do hope that, as my colleagues have told me, they have explored multiple ways to assure that this will happen, and that they will find a way that we can ensure that, albeit in a fair competition, participation in these public procurement projects that are organized in Romania will benefit from an as large participation as possible in order to ensure that European consumers get the best products at the best price. So it is in this key that I hope that these discussions will continue. And with that, I thank you all for participating, and give this away to Iuliana, I suspect, or Daria.
Yes, thank you, Paul. Good afternoon, everyone. Bună ziua tuturor. Dobry den. Mulțumesc. Thank you for being here today with us, here at Mușat and Associates, and online. We have more than 600 people who are joining us, watching online on JURIDICE.ro channels. I am very honored to moderate this debate again with Iuliana Iacob, partner at Mușat and Associates. And it is our fourth debate together. And I'm very interested in the topic our hosts choose today about the access to the European Union procurement market for third countries. Considering the last European Commission proposals by European, so the topic is very interesting, and I give the floor to Iuliana and her colleagues.
Thank you, Daria. Thank you, Paul. Wonderful to see everyone again. We'll hear from each of our wonderful panelists very soon. As Daria mentioned, and as Paul, I think, gave us a flavor of, this is a timely, interesting, insightful topic. The recent decision in the Colin case has definitely made headlines over the past few months, since the CJUE rendered its judgment in October last year. And we'll look at the ramifications, the effects, and the potential questions very soon. Just perhaps I'll start by introducing our panelists. And I'm very, very grateful to share the floor with our excellent speakers today. Perhaps I'll let Daria begin.
We are starting with Iulian Popescu, one of the leading business lawyers in Romania, Deputy Managing Partner of Mușat and Associates. Iulian has a vast experience in public procurement. He represented a lot of businesses in large civil infrastructure projects in military acquisitions in Romania. So I'm honored he is with us today.
Thank you for having me in this discussion. It will be most interesting to debate with everybody on this hot topic for Romania. And the fact that we are discussing this in Romania, it makes me proud. Until then, this kind of high-level discussion on European law interpretation were made in London. Now we are discussing about two cases, both one with Colin. I don't know if Colin is in the room, that is present on the Romanian market, and the second, a case against the Romanian authority with a consortium made by part of it by Romanian companies. So Romania has become relevant. So thank you for this invitation.
Thank you. Also, we have Ana Maria Abrudan, with whom we had last year a debate too. Ana Maria is partner at Mușat and Associates and has a vast experience in public procurement also.
And actually take some time from your precious time with the public sector to carry out
We are also joined by Değer Boden. Değer unfortunately can't be with us presently. An urgent last-minute commitment intervened over the weekend, but it's a genuine pleasure to have her join us online and contribute to this exciting debate. Just very briefly, Değer is a founding and managing partner of Boden Law. She specializes in arbitration. Among other, she truly is, I think, a Renaissance practitioner from many perspectives. She's routinely recognized by leading directories, and she has extensive experience in investment treaty arbitration and complex commercial disputes, in addition to serving as the chair of the Energy Commission of the Istanbul Arbitration Center. And she brings a unique perspective and unique insights into the challenges and the reactions faced by non-EU economic operators, such as Turkish companies, for instance. I hope that, and yes, I see Değer on the screen.
Yes, I'm here. Thank you. Yeah. It's great sharing the panel with you. And sorry again for not being there physically. I hope to be able to make it there.
Bulancea with us. It's a genuine honor to have her participate to our debate today. Just very as a way of introduction, she is Chef d'Unité at the Court of Justice of the European Union. She has vast experience as a magistrate. Since 2009, she has been a judge at the Bucharest Court of Appeal and also a lecturer at the National Institute of Magistrates in the field of administrative and competition law. And in the past, she has also had a role within the government agent for the Court of Justice of the European Union. There's Dr. Wojciech Sadowski, a partner at Queritius. Wojciech focuses his practice on international and transborder dispute resolution. He acts as counsel and arbitrator and has broad experience in commercial arbitrations and litigations before domestic courts, but also before international courts such as European Court of Human Rights, General Court of the EU, and the Court of Justice of the European Union. And Wojciech will also bring, I think, his perspective from a different jurisdiction, but also from the CE area in general.
That's true. I don't have much to add, except that I'm grateful for being here and looking forward to this discussion.
Considering how hot it is outside, inside, and our topic, I think we can start this debate.
So just on the final note, this is a new emerging topic. We are talking about cases, judgments, opinions that are have been recently rendered, and subjects, topics that have generated debate, that have given rise to numerous questions. So we hope that this is a genuinely interactive discussion. Don't hesitate to ask questions, to interact and to interrupt us. We're looking forward to shedding some light on this new, interesting and engaging topic. And there are essentially no right answers. There's just a great opportunity to shed light on a very timely discussion. So without further introduction, perhaps let's, and because so much has already been said about the judgment in the Colin case, perhaps that's a great way to start. And I think I'll turn to the screen now and give the floor to Diana and invite her to perhaps just tell us a little bit about the main, the key takeaways in the Colin case, in the Colin judgment. What is it about? What is all the discussion concerned?
Hello, everyone, and thank you so much for the invitation. It's a real pleasure to be part of this discussion, even from afar. I hope so the technical difficulties will disappear. Before diving in, I just want to make a quick clarification. I'm taking part in this debate today in a personal capacity as a legal professional with a real passion about the field of public procurements. What I'll say reflects my personal view and not those of any institution I'm affiliated with. I hear me twice. It's a little bit weird. So nothing I say should be taken as representing their official positions, whether the Court of Justice or the Bucharest Court of Appeal. Now, getting into the substance of our discussion, I'll start with the first topic assigned to me, the key consideration in the calling judgment. For a quick reminder, the calling judgment addresses the participation of economic operators from third countries in public procurement procedures within the EU, particularly those from countries that have not concluded an international agreement guaranteeing equal and reciprocal access to public procurement procedures. In my view, the key considerations established by the court are 4 or even 5 and relate to the first one, the European Union's exclusive competence. The second one, the discretion granted to contracting entities. The third one, the non-recognition of the right to equal treatment for economic operators from third countries. The fourth one, the role of national law in decisions of national authorities. And the last one, the inaccessibility to the preliminary ruling mechanism in the similar cases. In the following section, I will address each of these topics, paying a particular attention to the first one concerning the exclusive competence of the European Union. So, as I said, the first one concerned the exclusive competence of the EU in regulating access or participation of third country economic operators to public procurement procedures within the EU through acts of general application. In this crucial point, the court had to decide whether the procedures governing the award of public contracts in the EU fall within the internal market, a competence shared between the EU and its member states, or the common commercial policy, an exclusive competence of the EU. The court ruled that, since the common commercial policy concerns trade with third countries and encompasses any EU act which is essentially intended to promote, facilitate, or govern such trade and has direct and immediate effect on it, any act of general application specifically intended to determine the arrangement under which economic operators from a third country may participate in public procurement procedures in the EU falls within the exclusive competence of the EU in paragraph 57. And so, only the EU has competence to adopt an act of general application concerning access to public procurement for third country economic operators, whether by guaranteeing their access, excluding them, or adjusting the evaluation of their tenders. These acts may either be agreements, bilateral or multilateral agreements between the European Union and a third country or many third countries, or acts which, in the absence of such an agreement, unilaterally determine whether, and if so, under what arrangements the economic operators of that third country may participate in public procurement procedures within the EU. In paragraph 67. What that means for the member state? That means that member state may not reclaim competence in this area, even if the EU has not yet legislated on access. And so the member state may not adopt any act of general application concerning access to public procurement for third country economic operators. The second one concerns the contracting entity's discretion in absence of EU rules, paragraph 63 and 64. In this so-called, by some scholars, legal or normative vacuum, the court recognizes a certain discretion for contracting entities, allowing them to decide on a case-by-case basis whether to admit a third country tenderer. The court expressly noted that, in the absence of act adopted by European Union, it is for the contracting entity to assess whatever an operator for a non-covered third country should be admitted to a public procurement procedure. In my view, since such a decision by the contracting entity will be an individual act, not one of general application, this assessment is permitted under the court interpretation. The third one, no right to equal treatment for third country operators. Economic operators from non-EU countries that have no procurement agreement with the EU cannot invoke the principle of equal treatment, either under EU law, Directive 25, or national law transposing that directive. Paragraph 67. Both the court and the Advocate General observed that operators like Colin, established in Turkey, a country with no EU procurement agreement, do not fall within the scope ratione personae of Directive 25. So, the equal treatment and procurement rules in that directive do not apply to them. The fourth one concerns the role of national law in governing procurement decisions in paragraph 66. The court clarified that if a contracting entity allows a third country operator to participate in a procurement procedure, its treatment must comply with national law rather than EU law. However, basic principles as such as transparency and proportionality may still be relevant, but only within the national legal framework. And finally, the fifth point arising from the judgment in the Colin case, in my view, pertains to the inadmissibility of preliminary ruling procedures in all situations similar to the one in this case. This means that as long as no general act adopted by the EU regulates the participation of third country operators in such procedures, and only the rights of operators from third countries whose participation has been accepted are at issue, which cannot derive from the Union law, the court will not be able to exercise its interpretative jurisdiction provided for in Article 267 TFU. These principles clarify that third country operators without agreements have no guaranteed rights under EU law, and their legal standing depends entirely on national law. In my conclusion, Colin has established the foundational legal framework, without an EU procurement agreement, third country operators have no guaranteed access or equal treatment rights under EU law. Any change to that framework will come from EU-level action. Future court judgment will likely accompany such developments. For example, clarifying the application of the EP regulation or new trade agreements. Thirdly, providing more detailed guidance on how and when third country economic operators may participate in EU public contracts. Until then, call-in remains the key reference, ensuring that the question of access by foreign tenderers is addressed at the Union level for the sake of reciprocity and uniformity, rather than by divergent member states' general measures. The second, I can stop here for the first topic, or if you want, I can continue.
It was definitely, I think, an excellent foray into what makes the call-in judgment so unique and so talked about, I think, at this stage. I'm very grateful to Diana for the excellent presentation, and I've zeroed in on one of the key elements in the presentation, and there was this mention to no guaranteed access or to equal or no equal treatment. Having this being mentioned, I think the immediate question that arises is what has been the impact of the call-in judgment in this past few months that have passed since October? What are the effects? What are the effects on contractors, on economic operators, be it from third countries that do not have a public procurement agreement in place with the EU, or perhaps EU economic operators that are part of a joint venture together with a non-EU contractor, non-EU economic operator? How has the call-in judgment impacted or been interpreted by domestic courts, by contracting authorities? And perhaps maybe we can turn to Anna just for a brief, her views on this matter. Yeah. How is it in Romania at this point? How are Romanian contracting authorities adapting to it, and how are economic operators reacting to it in turn?
So, in the last few months, this call-in case created a lot of confusion, not only between contracting authorities, but also led into competitors from EU member states. The lead to speculate around distinct interpretation of this call-in case. So far, we don't have a unitary interpretation, neither by contracting authorities nor by the CNSC or the courts of appeal. It's a very new case law. It's which currently, as we are also discussed today, is still putting a lot of questions. So, through this call-in case, what we saw is that now contracting authorities can adopt three possibilities: either to directly exclude third country economic operators, and from my point of view, authorities will not proceed with this first solution in lack of having the current applicable legislation amended, or to admit this kind of third country economic operators to the tender procedure and adjust or apply distinct scoring criteria to them, or to admit them without any adjustment criteria. In Romania, from November, we saw that this created, let's say, a tool to push an own agenda of authorities, leading to decisions that in some cases didn't make any sense and somehow exceeded the actual content of this calling decision. What I'm talking about is the fact that we saw in various cases that not only authorities but also competitors speculated that a third country economic operator can no longer contest. So a contestation made by such an operator should be inadmissible per se, just for being a third economic operator. So here we had distinct results, not only before CNSC, but finally we have a great solution also before the Court of Appeal, which said no, this was not the sense of this calling case, because this will breach other sovereign principles and rights, which is around the free access to the justice. So, to be more specifically, in the last few months, we saw not only distinct resolutions in practice, in jurisprudence, but also in the new tenders documentations, where it seems that authorities do not know how to apply it, and either they didn't mention anything about this case, they didn't put it the automatic exclusion criteria, they didn't add, let's say, distinct selection criteria or scoring factors. But we saw also new tender documentation where authorities added a short line at the section related to the technical capacity, a short line making reference to this calling case without any other interpretation of it. So we will see how it will be interpreted on a case-by-case basis in this type of tenders. From our case practice, we had a great solution recently, great and positive outcome of the council, which stick with us with the argumentation, and hopefully also with the one of the Court of Appeal, but which is not accessible now. And said that no, this was not the line of the calling case, and an operator from a third country can contest. But indeed, as we heard earlier, such economic operator in its contestation should rely only on the national law, benefiting still on main principles such as proportionality and transparency, which these two main principles are still the main principles in public procurement. So we cannot exclude them from this area. So this is, let's say, an introduction about what is now created. It's still confusing. It's a confusing factor and disturbing, let's say.
What are some of the challenges that I think both practitioners but also contracting authorities probably are tackling at the moment? And before perhaps asking Wojciech to tell us how are things in Poland and across the CEE area, because I know that Diana has some severe time constraints, and we're very grateful to her for making the time to join us today. Perhaps we'll just turn to her once again to see if, having also heard Anna's few comments on well, the tentative and initial case law and interpretations that have begun to crystallize, there are any other comments or issues that you would like to address when it comes to the judgment in the calling case, but perhaps the general issue of access to the EU market in general.
I think that this last solution, it's a good one in my view, because the Colin case doesn't refuse the access of the justice for the third country operators, but they can rely on the EU law only. So my natural question is the court referring here in the paragraph 66 only to the substantive legal rules under which the national judge could examine compliance with the principle of transparency and proportionality, or else also to the procedure legal rules. So the third country operators have this kind of to go to the administrative jurisdictions or directly to the courts. This is one question. And the other one, yes, we must apply the other principles and provisions from the national law, not from the EU law. So those two principles not in the light of the interpretation of the Court of Justice, but in the own interpretation of the national jurisdictions. I hope I answered to the question.
Thank you very much. Thank you to both of you. As promised, perhaps Wojciech will tell us how things stand in Poland when it comes to the Colin decision.
Thank you,
Is it
Juliana.
less confusing?
Thank you, Juliana. Before starting to speak directly on the Colin judgment, I would like to take one step back. Poland, of course, is a big economy, a big market, and one at which the discussion about local content and protectionism started sometime before Colin. That was probably a reflection of Polish companies who went outside Poland and tried to conquer other markets, including in the European Union, but realized that the concept of the common market or the single market is utopian, that they were not treated the same way as the local companies were, including in Western European countries. So there was this growing voice of the Polish business, which was calling upon the Polish government to take on protective measures to protect Polish market for Polish companies and so on. And of course, everyone realizes it's very difficult, almost impossible to achieve within the European Union. But then again, there's a lot of competition for Polish businesses, also from third country economic operators, or should I say, unprivileged third countries in the terms of Colin, because some third countries, of course, are parties to the GPA, and they are included by the standard of protection and the prohibition of discrimination. So when the Colin judgment came out, there was, of course, a lot of enthusiasm on the part specifically of the Polish contracting industry. There are lots of companies in Poland in the construction infrastructure business that welcome that decision. The voice of those companies was that they are facing undue, unfair competition from outside because there are certain operators who are not obliged to follow the same strict EU regulations, whose cost of operations are lower, who can be subsidized by their governments, who have deep pockets, and who came to Poland with predatory pricing. They would cut off the competition and they would jack up the prices. That was the real concern and very enthusiastic response to the Colin decision. Subsequently, in early February this year, a draft law appeared, was brought to the parliament by a group of MPs that sought to essentially repeat the basic principles of the Colin judgment, which are that the operators from the EU and the privileged third countries, such as the parties to the GPA, should be afforded non-discriminatory treatment. However, the contracting bodies can differentiate the status of third country operators from the operators from unprivileged third countries. That draft bill, however, very recently at the end of February was withdrawn from the parliament, and it's understood that it is supposed to be replaced by a new draft bill, which is being currently prepared in the Ministry of Infrastructure. However, I have been unable to acquaint myself with the details of that draft law. Apparently it's being still processed. In the meantime, however, the Polish Public Procurement Office issued several communications on the interpretation of the calling judgment. And those communications can be distilled, I think, into 4 points. First, there is no automatic exclusion of operators from unprivileged third countries, meaning that if a contracting body wants to exclude them, it has to do it on a case-by-case basis. If they want to do so, they can either exclude operators from unprivileged third countries altogether, or they can differentiate the treatment. However, they can also allow them to participate in tenders on the same grounds as operators from the European Union, so they can still adhere to the non-discrimination principle. Finally, seconding what Diana said, to the extent that operators from unprivileged third countries are admitted to participate in tenders, they cannot rely on EU law. Especially, they cannot ask preliminary questions to the ECJ, and they cannot rely on EU law. They cannot invoke EU law in their to support their positions. So far for the communication of the Polish Public Procurement Office. There was one case, at least, which was decided by the Public Procurement Appeal Body in Poland concerning a tender organized in Gdańsk, a city in northern Poland where I come from, where the contracting body decided to exclude a Turkish company from the tender, relying directly on the calling judgment. That company appealed, and successfully, because the appeal body found that the tender specification was announced and the tender was organized before the calling judgment was handed. So the tender specifications did not differentiate between third country operators and EU operators. So the contracting body could not retrospectively exclude an operator from from Turkey, relying only on the calling judgment. So that's this decision. And insofar as it concerns the tenders which are organized in Poland, generally the contracting bodies do not apply the calling judgment. There's only one exception, a major tender for rail infrastructure as part of the Via Baltica, which is the rail line connecting Poland with the Baltic states, where the railway infrastructure operator in Poland specifically excluded operators from non-privileged third countries. Other than that, I'm not aware that calling judgment was applied more broadly. I guess there are two explanations for this. First is that there's, of course, a clear tension between the interest of domestic contractors who want the third country operators to be excluded, and the contracting bodies, which are mostly public authorities, who want to get the job done at the lower cost possible. So they are supportive for more intense competition, and Poland is a very competitive market. So presumably that's the first explanation. The second being that, if you want to differentiate the criteria, if you want to differentiate the legal status of operators according to their origin, you need to put in some extra work and create those additional tender specifications. And that requires some efforts. Maybe nobody still knows how to do this exactly. So I would assume one or the two reasons why it's not happening. So far for my preliminary comments. Thank you.
I think this sets the discussion perhaps for hearing or exploring how economic operators from third countries, and third countries such as Turkey, for instance, or third countries that do not have preferential public procurement agreement with the EU in place, or have not adhered to the WTO GPA. And perhaps Değer is best positioned, and then I'm looking at the screen again, positioned to help us answer this question. How have Turkish companies, for instance, reacted to the calling case? What are the legal remedies that they have pursued, or the legal courses of action to adapt or to adjust to the calling judgment, or what are the courses of action that they could potentially contemplate? And because we've mentioned the WTO GPA, for instance, is there are we looking at efforts to intensify, for instance, the adherence to the WTO GPA? Is this going to be an incentive, for instance, perhaps for for other third countries to negotiate the preferential public procurement agreement with the EU, or are there other potential courses of action available?
Thank you, Iuliana. I mean, it was very interesting to hear from different interpretations from Europe, from Poland, from Romania. Of course, this judgment is subject to many different interpretations, but I can tell you that it gives to contracting authorities a great tool for protectionism, for by Europe kind of policy. I think it is now the trend in the world. I mean, if we look at what Trump administration is selling, like by American policy, now it gives a tool to the administrative authorities all around the European Union to apply this nationalist or by European kind of policy. So, although, I mean, all speakers mentioned details about the judgment doesn't explicitly prohibit participation of participation of economic operators from third parties. However, the judgment mentions that without having a reciprocal access to public procurement markets, they may not benefit from EU law. So if a contractor cannot benefit from EU law or public procurement laws in terms of equal treatment, it is indirectly a restriction of access of third countries to public procurements, to my opinion. And of course, this in that case, I want to also mention a few points for Turkey. As you may realize, it doesn't say contractors, but economic operators from third countries. And economic operators are defined in EU directives very broadly. It covers suppliers, manufacturers, or other persons who distribute supply goods, etc. And just to let you know, Turkish firms export 45% of their products to European Union. And if it is related with supply of goods, if the public procurement is related with the supply of goods, it may really affect trade business as well. And I want to also highlight a few points specific for Turkey. Turkey is not any country. I mean, for EU, as you may all know, Turkey was in the process of adhesion to European Union, and we have gone through a few processes. And Turkey does not have a free trade agreement, but Turkey and EU have a customs union, which was a step in this process, and which allows free movement of goods, but this specific agreement excludes services and public procurement. Having said that, this specific custom union Turkey is party to provides a system called common external tariff. What does it mean? Under this rule, Turkey must adopt the same import tariffs as EU applies for industrial goods from non-EU countries. For example, if EU signs a free trade agreement, let's say, with a third country, and Algeria, whatever. And in this free trade agreement, if Algerian products have access to EU, then they are automatically having access to Turkey without a direct agreement with this third country, with Turkey. So it is a huge burden on Turkey, because Turkey has no authority to negotiate this free trade agreement with third party. And Turkey does not have the same rights towards this third country. So now we have customs union, and Turkey is under obligation of this common external tariff, and without having reciprocal public procurement rights. So here, your first question was what are the legal tools available? Of course, we can discuss bilateral investment treaties. We can discuss other tools, WTO or trade-related tools. However, in the first session, I can say that it is a policy shift in Europe, and Turkey needs to renegotiate the customs union customs union with Europe in a way that it covers public procurement, and also it should be modernized and renegotiated. I mean, what has been discussed in Turkey, and there are very limited news and very limited articles published on the topic in the Turkish market. But the common reaction is for the government to negotiate the customs union as soon as possible and renew it in a way to include public procurement. So would you like to go further for legal remedies, or is it sufficient for this time?
Thank you so much, Değer. Perhaps I've seen Iulian nodding while you were talking, and then the voice earlier. So maybe perhaps we can also give the floor to him and come back to the remedies issue, just to wrap up the discussion.
Thank you, Iuliana. Thank you, Değer. Well, I want to start by paraphrasing what Değer said. No, she's right. Turkey is not just another third country. Turkey is our close neighbor and friend, and a country with a lot of expertise and a lot of economic power, a big influencer in the region, and we want it here in Romania. And I hope Romanian authorities, as well as European authorities, will realize that sooner rather than later, that being protectionist is one side of the coin, being isolated is the other side of the coin. So European Union has started putting in place legislation that goes on the principle of balancing, because there is a good and bad in approaching this. So as long as I heard my fellow speakers talking, I more and more realize that my impression, and I don't have to have any disclaimer that I'm not speaking for a company or institution, is that call-in case is ahead of its time. Why am I saying this? It's ahead of its time because it has myriad implications that nobody has thought of when releasing. It is ahead of its time because it doesn't provide clarity on mechanism. It's ahead of its time because it creates confusion, and that creates impediment in commerce and in developments, in public procurement, in all limbs of economic activities of the European Union. And this affects citizens. It's ahead of its time because it conflicts with a lot of European Union legislation, and it has no remedy for this. And it's ahead of its time because European Union already has in place two key pieces of legislation to tackle two issues that people in the market usually think confuse them for one another. The principle that I noted down here somewhere is, how is it called? Let me tell you, protection of internal procurement market. And this is a rightful thing for the European Union. It has to protect its internal market. But this can be done, and this was about to be done, through two mechanisms. One, the so-called EP or IPI regulation, and the other is the foreign subsidies regulation. There are two questions that the European Union and the European Commission is asking itself. First, if we allow a level playing field for third country operators in Romania or in other European Union state, do we have the same level playing field in that country? And if we go into this, we will probably find out that in more rather than less of those countries, we don't have the same rights. And nobody has looked into Turkey, but I'm afraid what they're going to find. So it's a legitimate question from the European Union to ask itself, but it has a mechanism for that. Second of all, there was a lot of discussion on the market right now, and this is the confusion with the first question if we have a level playing field, is whether, for example, Turkish, because we are speaking about Turkish companies, whether Turkish companies benefit of subsidies and therefore come into the European market benefiting of these subsidies and competing against other European players, which they feel it's unfair. Of course, it's a competition problem as well. But European Union has already developed another mechanism for that. This is the foreign subsidies regulation. Both mechanisms, the IPI and the foreign subsidies regulation, have a certain mechanism. Both go on the same idea, balancing. First, get information. Second, assess. Third, put in balance what is good and what is bad for the European Union internal market, and then decide. None of these regulations have been applied. Some people will tell me, there was an investigation started in 2004. Yes, it was only one investigation started in 2004 after 9 months of scrutiny, which is normal because we are not doing things over the night like in other part of the world that we see more and more. We are scrutinizing, we are getting information, and we determined that, for example, China doesn't have a level playing field or is using subsidies. And then we put in balance and go towards a decision. No decision has been done yet. So, European Union, to tackle this, has instruments and has to put some effort into it and try to determine what is the impact of the internal market. It hasn't done so. Now we face ourselves with a European Court of Justice decision, and that creates a lot of questions. Of course, lawyers all over Europe and all over the world are inventive, and they are interpreting each article in a different way. We've heard one interpretation, but we can invent 1,000 interpretations, and then they all hold up. So to resolve this truly is to implement European legislation, actually. Second way to resolve this, I don't know if it's going to resolve it, is to wait for another case, another big case, the Qingdao case. What I want to clarify is the most confusion that was being casted over the subject was stemming from the Attorney General's opinions. The decision itself is not that unclear. But if you read the opinions that stood as a basis for the decision, you are totally confused. And you will see that in Qingdao, the ball goes even further, because they say that each state can modify its legislation and redefine economic operators in such a way as to exclude. Well, I understand. It can go this way. It can go and say that, like Poland can have a law, and I heard that they already attempted. They are faster than us, obviously, even in this direction. And have a law and say economic operators are this and that, except these countries. I don't know if this is the correct way. I don't know if Poland should take a decision or Belgium should take a decision. I think this can be resolved at the level of the European Union, because otherwise each country will do what it pleases. And we know Hungary will be very happy to do a different to any other European state. So I don't know if Qingdao will solve the issue or will further complicate it. Of course, we are discussing with Turkish clients every day. Because hopefully they will continue to have an interest, and I know they will, regardless of any hurdles, because and that's why I started the discussion by saying that now we are discussing principle of European Union law, how they combine with international treaties, what effect on the internal market here in Bucharest, because we have a market for this. Romania is in full development of infrastructure. And we started with highways, we have hospitals, we have military infrastructure now going on pending. But it will follow. It will follow with railway. It will follow with other areas we are underdeveloped. This is the truth. We have a powerful friend nearby, which is Turkey, and we need their companies, we need their expertise, and we would balance this if we are smart and we don't play it emotionally, that we want to be protectionist and we don't want any foreigners here, we can do it ourselves and dig tunnels to Egypt. No, this is not the truth. The truth is, even if they get subsidies, we benefit from that. We have lower prices. We benefit from their expertise. They can build faster, which is good for us. So we need to put it in balance. Of course, we are affecting local market. This is bad, but there are other measures less restrictive that can be applied in order to have a win-win situation. Now, of course, all participants on the public procurement market in Romania will not be stopped by these attempts. Currently, there is no impediment. They can participate, they are welcomed, and they will continue to do that because there are a lot of projects going on. In the future, I am not guaranteeing that it will be as easy as it was until now. There are two possibilities right now contemplated by Colin. One, and King Dao, I want to add here. One, it is the possibility for Romanian legislator to modify legislation. I doubt that. I doubt that they will take the lead. I doubt that it's in our interest to take the lead. Second of all, you can have worse public authorities deciding for themselves. And let's say they will put in the tender documents a line saying that non-EU companies are not welcomed and they will be excluded. Well, based on what? On the possibility granted to us by Colin. Well, and you will exclude all or some particular countries. We haven't decided yet, but maybe all. Would you exclude them as main bidder or as, let's say, part to a JV? Well, we don't know. If they are there, we will exclude it anyway. So you will exclude the entire JV, even if the JV is 5 Romanian companies and 1 Turkish company. Well, we don't know. That's what I am telling you. Are you going to exclude any third country operator being a subcontractor or a third supporting party? Well, we don't know. That's why you can't exclude, because you don't know. You don't know what to apply. There will be voices saying that, well, you can guide yourself by reading those 2 European pieces of legislation that I invoked earlier, the IPI and the subsidies regulation. But, well, they were not applied by the European Commission itself. No assessment was done. Who will have the economic power, knowledge, and time to do these assessments? Can, for example, the road administration in Romania send a letter to the Turkish government and say, are you helping these Turkish companies? Do you accept, let's give me an example, Concelex from Romania to participate in Turkey on an equal playing field? Can you give us documents for that? We want to assess, because we want to decide whether to exclude or not. Even worse, if they think of deducting points, how will they calculate points? Based on what? Can they determine the effect and how this will be reflected as a figure in the tender to say, let's deduct 2 points from the Chinese companies and maybe 5 points from the Libyan companies. How? And this will be highly challengeable. It would be very nice for us. We as lawyers can find out tens of arguments that they are breaching whatever, you name it. I don't even know where to begin. They would be breaching. They will not be doing this. And if they will be doing this, then it seems we are on the right trend. We are, as the leaders of the world, going emotionally going and giving pieces of decision legislation each day. So I don't think this will be an approach by the Romanian contracting entities. And I've heard from Ana Maria that they are already putting a line. This is so typical Romanian. They are putting a line, and please take care of the calling case, and please mind the calling case. What does it mean? How should we mind the calling case? We don't know, but we just put a line just to be in compliance. So this is the way the public authorities here in Romania resolved it until now. So I don't think they will, unless there is a political decision, I don't think they will do this. And I don't think it's in our own interest. But there are, and one more minute, I will tell you that companies already think to tackle this in other ways, by shifting their structure of participation. First of all, and this is a good thing, the message was given by the European Union. Hey guys, we want you here. We want for you not to take the profits, all profits home. Let's invest here. Let's have some companies stable on the market with some employees, with some people paid 12 months a year. And one possibility is for them to start creating subsidiaries. I mean, with distinct legal personality, and start having meaningful business operation in Romania, because this will be the test. Do you have meaningful business operations in the EU or not? Meaningful meaning that you have employees, you have contracts year round, and you have money going in and out. Second of all, if you don't have, and we question this business, this permanent establishment, we will look at your origin and at control. So first option would be for third country operators to start establishing subsidiaries in Romania and have meaningful business operation. It is not a representative office. Second of all, they can say, okay, let's use the joint venture participation format. And let's get in our JV European companies, Romanian companies, Polish companies that are allowed, that are privileged. And they will, right now there is no limitation, but they cannot ignore the IPI regulation. And they will have to look, there are some thresholds there, some indications, because there might be another European Court of Justice decision that will go in that direction in the IPI. And as it was discussed before, we expect that Qingdao may tackle this as well. So please look on this regulation and see that you shape your structure in a way that complies with it. Third of all, they can go and, let's leave aside the JVs, they can go as subcontractors. There is also an indication in the IPI on subcontractors, and you will see that there are some thresholds there as well, that if you comply with, you may be on the right path to a certain safety in the future. And last but not least is third-party supporter, and we know that there is no regulation right now. There is no IPI mentioning of this. However, a caution approach would be to think of any participation structure as being one single entity, the participation structure, with any kind of positions occupied by different people. So if you look a little bit of this regulation, if you look a little bit of what can happen on the subsidies, you may anticipate, forecast, and plan for staying in a big market like the European Union, and benefiting of the advantages. However, I'm a European, so I must encourage, please look also into the GTA agreements or other kind of agreements, and let's have Romanian companies on other markets as well, on a level playing field, because sooner or later all these possibilities that are now a lot of possibilities, and we work on solutions all day, will close. Because at the end of the day, people will check whether a builder from Romania can go on the Turkish market and be accepted identical conditions with a Turkish company. Thank you. I have already took a lot of the time, but this is my trademark.
Thank you, Iulian. A true business lawyer approach and so many solutions. Let's hope that among those more than 800 people who are watching this debate online are representatives of authorities and our colleagues from a legislative system, and we'll make sure they will hear your message. I want to ask Değer if she wants to add something on the remedies and solutions in Turkey, and after that I'll give the floor to Volchik.
Yes,
Yeah.
yes. First of all, I agree with Julian in terms of practical solutions. As for the Turkish construction companies, to the best of my experience and my knowledge working with them, I can tell you that they are quite result-oriented and practical companies. And if they see any problem in any jurisdiction, they automatically ask what is your suggestion to solve this problem. So I think they will follow what Julian said, and they will add one more item to their initial due diligence checklist as a question checking in the relevant jurisdiction how the administrative authorities interpret this decision or other similar decisions, and how the administrative public procurement authorities reaction, and what is the regulatory or any other jurisdictional risk in this country. I mean, of course, it will be subject to a lot of legal risk assumption in the country they make business or investment. I mean, we can talk about the tools available for Colin or other contractors from third countries. As an arbitration practitioner, my first reaction when I first read this decision was to check bilateral investment treaty between Turkey and Croatia. And I mean, of course, any investor can bring an investment treaty arbitration case against the country. However, it may first condition that it should fall within the investment definition of the relevant bilateral investment treaty. And of course, this investment definition differs from BIT to BIT, and investors or contractors should be very careful about the investment definition and then the rights provided under the relevant BIT. I mean, Turkey has more than 100 BITs with different jurisdictions and countries, and Turkey's BITs are quite modern, covering many rights and broad rights like FET provision, most favored nation provision, national treatment, etc. But if the relevant BIT does not cover certain rights, it might be difficult to base the arguments on expropriation or anything, because it's in a very early stage, like public procurement. I'm assuming that if there is any kind of bilateral investment treaty arbitration case claim, that would be very strong counter arguments, there was no investment at this stage, and it is a policy decision, policy change, and it has nothing to do with discrimination or etc. So, I mean, it's not an easy option. I would say it requires a case-by-case examination. And as a tool, it is there, but you need to base your arguments on each case from the facts, whether it may fall within the investment definition, whether it is a protected investment with broad rights in the investment treaty, what is the case law, on similar cases, etc. So, I mean, investment arbitration is there as an option, but I don't think there is sufficient damage here in this specific issue. And as I said, it requires a lot of examination. And second option I may think of, but we have experts here from the European Court of Human Rights, etc. Maybe they can comment better. But what I was thinking whether any potential, I mean, any company, third country company can bring a case in the European Court of Human Rights in terms of breach of human rights, because it may well trigger Article 14 together with other rights like right to property, etc., because it's not a standalone claim, as you know. I mean, there are cases where companies can also bring human rights claims in the European Court of Human Rights as a breach of human rights. Not only individuals, but companies can base, but it's also a difficult option. And there are some other options like Turkey can bring a case under WTO or customs union kind of violation, but it requires Turkey's involvement, not Korean's involvement or other third-party Turkish contractor companies' involvement. So to sum up, there are ways, but none of them are straightforward and easy. I think Turkish contractors at this stage will just see the approach from different jurisdictions in Europe, and they will just follow the advice of their lawyers in terms of, you know, complying with the new requirements, how to fall within the new kind of requirements, establishing companies or, you know, acting as subcontractor, as Iulian explained. But I mean, I need to highlight once more that Turkey needs to renegotiate and revise the custom union as soon as possible. Thank you. Thank you.
Wojciech, if you want to add on remedies?
It's working. Thank you, Julia. Okay, so I would like to start by saying that I don't necessarily disagree with the calling judgment as the application of the EU law. And as a matter of fact, if we look at the substance of the judgment purely from the EU, from the perspective of principles of EU law, it's a correct application, because there was a third country operator. There was an operator from a country which is not a member state of the EU. So the question which was referred by a Croatian court was not an EU situation. So that the result was correct. The fact is that, incidentally, it also created a waterfall of consequences for the entire European public procurement market, but I'm not really sure that the judges in Luxembourg were fully mindful of this and the consequences they would be creating. But here we are. Second, I think that inconvenient, perhaps, as the judgment may be, it's like a block in a road on a middle lane of a 3-lane highway. It doesn't block the road completely. It can be very easily circumvented, like Julian said. Even based on the calling judgment itself, it's enough for an operator from an unprivileged third country to set up, or actually to channel all the tenders following the calling judgment through subsidiaries, which probably in most cases already exist, either in, not necessarily in Romania, but any EU member state, and not only that, any state that is a party to the GPA or an equivalent agreement. So most of those operators are already large multinational companies originating from one of those unprivileged jurisdictions, but they have subsidiaries in different places around the world. So I suppose that if the contracting authorities take the effort to adjust to the calling judgment and exclude or aim to exclude operators from unprivileged third countries, they will respond by putting in tenders through their subsidiaries in those jurisdictions and fall under the protection of the EU law. As to the possible application of the bilateral investment treaties, that's also something that crossed my mind immediately when I read the judgment, because it smacks so much of the Achmea and similar judgments. And there are a couple of tricks concerning potential application of BITs. First is that, and for the reason of those tricks, I think it will be extremely unlikely, although not impossible, that this remedy will be used. First is that almost all bilateral investment treaties of the EU member states with third countries, including Turkey, include the RIO exception, or the exception for limitation of rights, exception for the discriminatory treatment resulting from the regional economic integration operations, such as organizations such as the EU. So essentially, the BITs enable member states to discriminate investors coming from other states because of the participation of the EU member states in the European Union. But, and here's the but, the calling judgment also says it's not only EU member states, but also the member states that are parties to the GPA. And because the calling judgment orders member states to afford equal treatment also to the non-EU member states, which are party to the GPAs, then the operators from unprivileged countries may say, hey, you're not only discriminating us against the EU member states, you're also discriminating us from operators from third countries, which are not the member states of the EU, so you cannot rely on the RIO exemption here. So this shouldn't be an obstacle for us, preventing us from bringing the claim. But there will, of course, be other problems, like, does the operator have an investment? Because in most cases, the exclusion from the tender would happen before the contract is awarded. So it might be questionable, and the state will argue that there was actually no investment because the contract was not yet afforded. Second, the exclusion from the tender just means for the economic operator that it lost an opportunity to participate in a tender. Who knows if they would win or not? So it's much more speculative in terms of loss, and that translates into problems with quantification of damages, and ultimately, from my experience, it's always about money. So it's the economic operator who would have to assume that they would want to go into a long-lasting process which would cost them millions of euros, chasing some elusive dream of getting some more money, where they are in the business of participating in tenders and being friends with the contracting authorities, most of whom are public authorities, so they don't want to make enemies with the government in any way, shape, or form. So they would probably not institute an investment treaty arbitration, but theoretically, and as a lawyer, I'm interested by these issues. It is a possibility. Same with the European Court of Human Rights. Even if arguably there is a case, it will take ages. I mean, the European Court of Justice, as we all know, is one of the slowest courts in Europe. It will take ages, and even if they award compensation, it never fully corresponds to the loss which is suffered by the injured part, by the applicant. So I think that pragmatically, using subsidiaries will be probably the most efficient and most widely used tool. Thank Thanks.
And then I've seen, before we open the floor to questions, I've seen Iulian nodding again, and I know he wants to add on what Wojciech has been telling.
Just short, I want to raise awareness that this discussion is important, and is important in three perspectives. One is the theoretical aspect of it, and we lawyers and legal practitioners will enjoy debating on what we can do, what we cannot do, how can we attack this, and how can we find ways to mitigate. But it's very important for third country operators, which obviously are affected, but it's equally important to Romanian operators. Because let me give you some idea from what tenders in Romania look like. They have very restrictive criteria, and a lot of Romanian companies go in third countries to find a relevant experience, to find relevant financial resources. So hitting these companies will hit Romanian companies as well, that will no longer be able to participate. It will be only the big companies over and over again, and you know what that will cause? The rise in price. So this discussion is very relevant for everybody, because I was discussing with somebody earlier on, and why should we come to this discussion? Why should we be engaged? Because we are a Romanian company. We don't care. We are protected. No, you're not. No, you're not protected, because you will participate in what you can, and when you can't, obviously we will call our Turkish or other companies from third countries that will share their experience with us. No, that will no longer be the case. That will no longer be certain. Sorry for keeping you. Iuliana, please.
Thank you to everyone. It was definitely an illuminating debate, even for myself personally. I've seen, and then I know that we've had an interesting participation today, and then I think that there are representatives of contractors from third countries, but also from public authorities, and I see legal practitioners and colleagues. So perhaps I'm mindful of the time, and I know that everybody's looking forward to the cocktail, but if there are any questions, either to us here, and then I know that Değer, I think, is still with us. I think we've got time we are actually, I think, running out of time, but we can continue the discussions during the break as well, and for the cocktail. Just allow me to give a huge thanks to our wonderful speakers today, to my fellow co-moderator Daria, of course also to Değer, and whom I'm very sorry that she wasn't able to join us in person today, as was the plan initially, but whom I know that we'll have the opportunity to see again on with another occasion, and we can discuss or continue discussing the calling case during the cocktail, if that's all right with everyone.
I would like to add that as an entrepreneur, I think everyone should have such good lawyers as those who attended this event today, with so many solutions and remedies. And I would like to thank everyone for attending today, and I would like to thank Mușat and Associates for hosting us and to have the opportunity to see such a beautiful sunset outside the window. Thank you.
Thank you.